Good morning. My name is Walter Nunes. I'm a senior staff attorney at the Disability Law Center. We're going to be talking today about rights regarding restraint and seclusion. We're going to wait a couple of seconds before the participant count gets a little higher. We've got about 23 people who have tuned in, and we're going to be starting, I think, pretty much now. I am senior staff attorney at Disability Law Center, as I said. I am at least a middle-aged man, maybe a little older than that. I have long brown hair, wearing a black shirt with a fancy racing stripe on it. My bookshelf is behind me. I use the pronouns he and him. And in addition to today's subject of restraint and seclusion, on August 24th, we'll be doing this again. And the subject matter will be filing a complaint with the Department of Mental Health. I'd like to take this time to introduce my colleague, Staff Attorney Ginger Gates. Ginger?
Morning, everyone. My name is Ginger Gates. I'm a staff attorney at the Disability Law Center. I'm a white woman in my late 20s. I'm wearing a black dress shirt and I have black framed glasses on. My background is mostly light colored. You can see my wardrobe and some artwork in the background. My pronouns are she and her. And I would just note that there are ASL interpreters available. I would also note that throughout the presentation, if you have any questions, you should feel free to drop them in the Q&A section or in the chat box. I'll be monitoring those sections for questions. And I would just note that the slides, you should have access to the slides as they were sent to you prior to the start of today's program. So Walter, back to you.
Thanks, Ginger, and thank you for reminding me that for persons who want to use the closed captioning.
Excuse me, this is the card provider. You can just click the closed caption button now for that. I have that working.
All right, so we're all set on that. That's terrific. Thank you so much, Mona. So we're going to get started. I've got a lot of slides today, and we're getting better at this, Ginger. I've learned a lot from my colleague, Attorney Gates, that we want to make this as interesting and as formative as possible. So we're not going to read all of the information on the slides. You're all capable of reading these are regulations from the Department of Mental Health. They're fairly self-explanatory. So we're going to, as we go through them, I'm going to talk about what I think are the bullet points on the slides. But in very few exceptions, we're not going to just be plowing through them and droning on reading them. But I wanted to start today by talking about sort of the history of restraint and seclusion, at least as it applies to the Department of Mental Health. Many years ago, I think it was about 10 years ago, SAMHSA, Substance Abuse and Mental Health Services Administration, awarded Massachusetts a grant. And the grant was a 3-year grant that only applied to DMH facilities, and the goal was to eliminate the use of restraint and seclusion, a very laudable goal. And actually, during the period of the grant, restraints and seclusions dropped by 1/3, which was pretty impressive. That led to my being a member of the National Steering Committee for the elimination of restraint and seclusion. And as time went by, Massachusetts had a state mental health planning committee subcommittee regarding restraint and seclusion. That time, the language turned from elimination to reduction. I've noticed that there's been an uptick in the use of restraints in DMH facilities recently, and give credit where credit is due. In a lot of the private hospitals, they've been very good at minimizing the use of restraint and seclusion. So it's a big issue. It's an important issue. I've never experienced it. I think I don't know how I would handle it. I think it's extremely invasive. I think it's extremely traumatizing. It is something which some states have been able to stop doing. Even in some prisons, they've stopped using restraints. Seclusion is also a problem, but I don't think it's as traumatizing. And forgive me because I don't have personal experience on that. But the use of restraints is particularly traumatizing to persons who have experienced it. So I just wanted to talk about that, and I want to talk about that. Our goal is to help people understand the seriousness of the use of restraints and seclusion, the standard of when it's appropriate, and the steps that can be taken to, if not eliminate, reduce its use. So on that note, I just want to say restraint, and we're going to focus more on restraint than seclusion. We're going to talk about seclusion, but primarily the use of restraints. Restraint is not treatment. Restraint is the failure of treatment. In other words, it is a last resort. It's when all else fails, and it should be. There are lots of techniques that are in place to reduce it, and we're going to talk about some of those. So let's start with the next slide, which basically tells us what a restraint is, and quite simply, it's a behavioral restraint, which simply means restraint or seclusion can only be used if there's a behavioral issue, which usually involves self-injurious behavior or violence directed towards another. And quite clearly, it is the intention of a restraint is to unreasonably limit behavior. Let's talk about the types of restraint. Next slide, please. The first is the medication restraint, which is fairly self-explanatory. It's when a medication is used to control the person's behavior, quite simply. And there is an exception to when medication can be used, not as a restraint, but when it's not a restraint, and that's when it's used to enforce a court order, a Rogers order or an 8B. Even though if a person has to be held in order for a court order to be acted upon, then that holding would be a restraint. So we have a medication restraint using straight up medication to affect behavior. Next slide, please. And then we have the mechanical restraint, which is self-explanatory also, although there are different types of mechanical restraints. The one that most people have observed is the use of straps on a bed, a gurney. We are seeing in some hospitals the use of restraint chairs, which there's some people really don't like the look of them. They find them frightening. You sit upright. That's the reason why some people like them, because you sit upright. You're less, you can look around, you can see what's happening. But one of the concerns that has been mentioned that I agree with is sometimes the portability of a restraint chair. In other words, you can bring it to places. It can be brought to a public area in a facility, and so the restraint can take place where it's observed by more people, which is a traumatizing effect on them, and it also might lend to them being restraints happening more frequently. I have no data to support that, but when something's easy to do, sometimes you do it more often. Next slide, please. And the last one is the physical restraint, which is oftentimes a physical restraint is an antecedent to another type of restraint. If you have to be held for medication to be administered, held to be placed on a gurney, that would be a physical restraint. In some instances, though, a physical restraint by itself is all that is done. The person is held, they calm down, they're let go. And when a person is held in order for another type of restraint to take place, then that counts as two restraints. And I want to get people to think about the incident of restraint, and that each restraint needs to meet the same legal standard. Next slide, please. And this is seclusion. And I'm not in any way trying to minimize seclusion or that it's not traumatizing. But seclusion is, as it sounds, it's involuntarily confined to a room where you're prevented from leaving, or you believe that if you try to leave, people will stop you, or you will receive punishment, consequences. And if you leave the room, I don't know, you can't go to groups, or if you leave the room, you can't go out for a cigarette break or can't get fresh air. That is absolutely unacceptable. Although it is used, it should not be done when a person has something that they have a right to do, such as access to the phone. There is an exception to seclusion insofar as sometimes people will be asked to leave a group if they're perceived as disruptive. That is not considered seclusion. They go voluntarily, collaboratively is what the language in the regulation. And what I wanted to do is I wanted to stop here and just ask if anybody has any questions on anything about the types of restraints and the difference between them. And then I want to move on to what I consider the heart and soul of this.
So
Anything,
Walter,
Ginger?
we did have one question. I am wondering if the inclusion of the word unreasonably in the definition of restraint is misleading, for even if there is an emergency reason to restrain someone, is it still a restraint? And
I kind of, go ahead.
I think what the question is maybe getting at is the circumstances under which a restraint can occur, which there's a very narrow, there are very narrow circumstances under which a restraint can occur, which I think we're going to talk about in the next slide.
Yeah.
So if there's anything that you want to talk about with relation to the word unreasonably being included in the definition of restraint.
I think that's important, and that was a good catch for the person who brought that up. I think what they mean by would say unreasonably. There are exceptions. You can. What we're really talking about is putting your hands on another person, and that is always problematic, whether you're in the community, in a hospital, or anywhere. I think what they mean by unreasonably limits, they're talking about it's not like, for example, sometimes someone might touch your hand if you're talking, or they just may have a simple contact with you. I think that what they mean by unreasonably, meaning that it's not reasonable. They are holding you down. They are fastening you to a bed or fastening you to a chair. It is unreasonable. I think it's good that the language is in the regulation, because while restraints sometimes may be necessary, they're really not reasonable. It's an unreasonable thing you're doing to someone. And that's what I think that it means by unreasonably limits your freedom of movement, because that's what they're doing to you. And if you're in a mechanical restraint, you're not be able to move your arms. You won't be able to move your legs. Sometimes they'll do a strap across the chest. Sometimes they'll even do a strap across the forehead, so you can't move your head. So I think that's what they mean by unreasonably. But that was a great catch, and I really appreciate the person who asked that. I'd like to put up the next slide, if that's all right, if I can move forward.
Sure. We just have one more question that I think is really relevant to this conversation.
Yep.
Is a timeout a collaborative separation? Is that something that would be considered a collaborative separation?
Well, I think what makes it a seclusion is that you can't leave.
Right.
It's not just go to your room. Mm-hmm. It's go to your room and the door is locked, or there's somebody standing in the doorway, or there are coercive methods that you cannot leave that space. Right. That's what makes it a seclusion. A timeout, they usually don't use that word that I'm familiar with in a psychiatric facility. I think if it's a timeout, like, Walter, why don't you go take a walk, calm down, or something like that. That's not a restraint or a seclusion. Right. If the person would then say, no, I'm not going to do it, and it escalated, it may lead to a seclusion or a restraint. But I think a timeout, now in schools or special ed programs where they do use the word timeout, and they have a specific room, a timeout room that the person cannot leave, that is a seclusion. But that's not in a DMH facility. It's a completely different standard, and I'm not prepared or experienced to really talk about the difference, although the use of timeouts in special education programs is of great concern to the Disability Law Center. I hope that helped.
Thanks, Walter.
Okay. To me, this slide, this regulation that we're looking at right now, 2712-8B, is where it all lives. And what do I mean by where it all lives? This is the bottom line. This is when a restraint, whether it's mechanical, chemical, or physical, or a seclusion, this is the test. And if it doesn't meet this test, it is not allowable as a matter of law. And I also want to point out, this is the test for every restraint. And we're going to talk a lot more about that as we go along. But I broke this into 3 simple paragraphs to really underscore what I think is a very high standard. This is a very high standard to meet, and if it's met, restraint and seclusion is lawful. I often challenge the use of restraints when it doesn't appear as though they've met this, I think, extremely high standard. So let's just talk about the first piece, which clearly I am going to read for the most part. And the key words here is a restraint or a seclusion can only used in an emergency. Okay, that's an emergency. And they define the emergency as the occurrence of or a serious threat of extreme violence, personal injury or attempted suicide. Now, just think about, to me, extreme violence. Use your imagination. What does that mean? Or maybe your imagination might say, what does it not mean? If a person, I don't know, engages in, I know some people will put an elastic band on their wrist and they'll use it to snap it and they'll feel a sensation which they use to calm. It may be considered violent, but it's certainly not extreme violence. And you could just start from a simple pat on the back to an actual physical assault. But I think the fact that they use the term extreme violence speaks for itself. The action is going to result in serious injury to the person or to somebody else. So extreme violence, personal injury, or attempted suicide. So, violence, as it's written, I interpret it to be against another person. You attack another person, you punch another person. Yeah, that's extreme violence. But serious personal injury, attempted suicide, they speak for themselves. The second paragraph makes it a little bit more clear. It says they only include situation where there's a substantial risk of the occurrence of serious self-destructive behavior or the occurrence of it, or a substantial risk. So it is, there's no time to wait. In the next paragraph, we're going to talk about imminence, but it's very likely to happen. It's not somebody saying, well, Walter's looking a little angry. I'm concerned he might, do something, but that's not enough. Substantial risk, moving towards a person, moving towards getting something, holding a chair over your head that you're going to strike a person with. Use your imagination. But again, extreme violence, personal injury, suicide, that there is a substantial risk that this is going to happen. And here is really, to me, the most important part of this regulation, that the risk is serious and it's imminent. Again, holding a chair up over your head, you're going to strike somebody with it. Cocking your fist, you're going to punch somebody. Imminent. But here is the part that I think oftentimes is missed, where there's a present ability to affect such harm. In other words, threats in and of itself. When I get out of this hospital, I'm going to find you and I'm going to mess you up. There's no present ability to affect that harm. Threats in and of themselves, inappropriate language, no matter how hurtful it might be, is not a basis for restraint. But here's something I really want people to think about, because we're going to talk about some data that I have, and I think we're going to talk to it in this section, is that for every restraint, a physical hold, a mechanical restraint, a chemical restraint, this test must be met. So think about this for a minute. If a person engaged in behavior that warranted a mechanical restraint, and they're in a 4-point or a 5-point restraint, what would be the basis for that person then receiving a medication restraint on top of a mechanical restraint? In other words, if a person is uncomfortable, or they're yelling, or they're cursing, or they're making threats, does that meet this test for the doctor then to order an additional restraint that requires this same standard to be enacted, particularly a mechanical restraint? And the reason I wanted to raise that is because I like to call this the compassionate restraint, and I'm not trying to be funny here, and I don't really think it's compassionate, but I understand. For example, we have some data here. I'm not going to say what hospital it's from, but this is accurate current data of what's happening in Massachusetts. In the, I don't know, the last couple of months, in a facility where there are 54 mechanical restraints, 44 of those 54 had the addition of medication on that person. Next month, it was 39 mechanical restraints with 33 uses of medication. 57 mechanical restraints with 44 uses of medication. Whenever I see a restraint and seclusion form where a person has been placed in mechanical restraints and they then have been subjected to a medication restraint, you have to ask yourself, where was the present ability to affect the harm? Or where was the present ability for that person to engage in extreme violence, personal injury, or suicide, serious self-destructive behavior, or serious physical assault? I've thought about this for a long time, and I would really like to hear from you folks as to what you would think would justify the use of medication restraint on a person who is already in mechanical restraints. Now, what I often hear from staff, and this is why I call it the compassionate restraint, because people will say things like, well, Walter was struggling so much. He was all red in the face. He was frustrated. He was angry. We thought that the medication would calm him down. We thought the medication would reduce the amount of time that he had to spend in restraints. And, I get that, but that is not a restraint. That's treatment, and it's treatment without consent. I'm not saying that people do that, add the medication on top of the mechanical because they're mean and they're looking to hurt people. But what I am saying is it is a very hard scenario to envision that a person in mechanical restraint has the present ability to affect the harm necessary to justify the use of a medication restraint. And with that, I'd like to open up, and Ginger, feel free to chime in. Anybody on the chat line, any questions? If we'd like to drill down on that, that would be really terrific.
Sure. So we have a comment. This is so true. The chemical restraint is the actual harm. In the outside world, it would be the equivalent of being arrested, handcuffed, and then tear gassed after the handcuffs. We also have a question. If this is the standard for restraint, how do hospitals get away with the number of restraints they perform? Plus, with most mechanical restraints, as you've noted, Walter, medical restraints are used as well. And I think they mean medication restraints.
That's right. And I think we need to be vigilant. The reason, we get data from hospitals, peer specialists, providers, human rights officers, they need to question this. Every time there is a restraint or a seclusion, there's a restraint form. It talks about what the behaviors were that the person exhibited prior to the restraint, what steps were taken to de-escalate. And we're going to talk about de-escalation. And then more times than I'd like to count, it will say types of restraint, and they'll have check off, physical hold, because sometimes it's all three. Often a physical hold is basically necessary to administer medication. You don't want a person moving their arm or part of their body when you're trying to inject them, but that's only for as long as it takes to do the injection. But sometimes a physical hold is used to put somebody on a gurney and strap them in. And then after they're immobile, they are then, there's medication administered. And I think that, my mother always used to say that adds insult to injury. If we talk about restraint and seclusion as being incredibly traumatizing, not just for the person who is restrained, but the person who does the restraining, and also the other people in the milieu, the people who observe it, who have to witness it or hear it, and it's all upsetting to all involved. And we are going to talk to what we call the happy part of this discussion. When we talk about the reduction of restraint and seclusion. I think that human rights officers, peers, and I think that persons who are restrained or secluded, perhaps, but I think it doesn't include, medication often doesn't include a seclusion. I'm not saying it can't, but it often doesn't. I think we have to be vigilant. I think we have to file complaints. I think we have to talk about this, and that's what we're doing today. So again, I'm going to open it up, and I'll try to answer questions because I think this is the most important of anything we talk about today, other than mitigating the use of restraints. This is the most important slide. Everyone should know this. So please, Ginger.
Yeah, we just have some comments about personal experiences. Every time I was restrained, I was given Haldol and Ativan shots. I'm a peer specialist now, and I can say that in those times I was only given a restraint form twice, even though he was restrained more than that. So I think, you know, these regulations are very detailed, but how often they're followed is, you know, sometimes questionable. And I would just note that, you know, as we're discussing these issues, you always have the right to file a complaint with the Department of Mental Health, which is something that we'll talk about in our next training.
Yep. I think that if a person experiences a restraint, I would invite them to not only file a complaint, but I don't think it'd be inappropriate at all to reach out to the Disability Law Center. In my experience, people who file complaints on restraints are oftentimes those complaints are not substantiated. When I've appealed restraints, the number dramatically increases for the number of substantiated complaints. Because, you know, this language, if you wanted to write, I don't want to say a winning complaint, but basically, if you want to write a winning complaint, you draw right from the language of the regulation that, you know, I was given medication while I was in 4-point restraints, and in leaving aside the fact that the mechanical restraint may have been justified, underline may, there is no justification for the use of medication. Now, you can brainstorm about it. I mean, you hear about, I've heard things where there was concerns about someone having a heart attack or a stroke, and that's a real concern. But that would be emergency treatment. That would be emergency medical treatment. That would not be a restraint. It would fall outside of restraint, and it should be noted in the record that what they were doing was they were intervening on a medical emergency. Sometimes a person will struggle against the risk things, and they will abrate their risk, and they may cause injury. Well, I've seen some clever nurses who've used old school sanitary napkins and put them inside the strap so that the person couldn't injure themselves, or a person banging their head against the wall. Well, sometimes it's a simple matter of just moving the gurney away from the wall so the person can't injure themselves. I think if a person is determined to hurt themselves, they may find a way to do it. But in my experience, I mean, we talked about numbers, 2/3 of all use of chemical restraints are done on persons who are already in 2/3 of the number of chemical restraints are done on persons who are in mechanical restraints. 2/3. I don't believe that 2/3 of the time the patient had the ability to affect the harm necessary to warrant the use of medication. Sorry for taking so much time on this, but this is so important. We'll take a few more questions, then we'll clip through some of the slides and then move on to mitigation of restraint and seclusion. Please.
We have a question. Why are there no red flags when both physical and mechanical restraints and medication restraints are used, especially in repeat events?
Absolutely.
Is that not an indication of failure of proper care and treatment?
Well, I don't know if it's an indication of failure of proper care and treatment, because we're starting on the premise that restraints is not treatment to begin with. However, we're going to do this in two parts, and I'm going to actually move to the second part relatively quickly. The whole idea for the reduction of restraint involves a debriefing process, which some of you may be aware of, and then oversight by management and training for staff and so on and so forth. So it absolutely should be a red flag. I mean, anyone who looks at these numbers it sees, why are we doing medicine 2/3 of the time when a person is in mechanical restraints? It's absolute. There's no excuse for it. They should absolutely be saying, what are we doing wrong that we're doing this, not once in a while, but I'd say as a matter of practice. So we have to be vigilant. We have to work on it. We have to prioritize it, and we have to keep working to stop what I consider to be a very outmoded practice. Any other question on this one?
No more questions.
Okay. Well, we're going to move a little bit swiftly through some of this next part. So we're going to look at, Ginger, was there something that I missed?
Nope.
Okay.
I was just saying we could move ahead. Thanks.
Okay, so we're going to go through the next slides quite quickly. So slide 10 talks about prohibitions on restraints and seclusion. The most important to me, they're all important, but the development of the individualized crisis prevention plan, which is exactly the first step in doing this, and that restraint is a last resort, and seclusion, they're last resorts after everything else has failed. Next slide, please. Talks about who can order, prohibition and requirements. Basically, you can't order PRNs as a restraint. You can't say, give Walter, I don't know, whatever it is, Adderall at 2:00 every day because they've noticed that's when I become anxious, and they're trying to get out in front of it. They cannot do that. They cannot put a person in seclusion who is also in mechanical restraints. Although when I was checking numbers today, I actually found a case where a person was in seclusion and in mechanical restraints in seclusion. Next slide, please. Which talks about who can order a medication restraint, an authorized clinician who is present at the time. Of course, you'll see it says anytime during the course of the emergency. So that's a pretty broad window for the authorized clinician to be present at the time. It's not before it happens, anytime during the course of the emergency, which is a little troubling. Or after a telephone conversation with the doctor, a nurse, or a physician's assistant. They can authorize a medication restraint. Next slide, please. Talks about mechanical restraints. This is also an authorized physician who is present, but if they're not present, they can be done by an authorized staff. That then reduces the amount of time from 2 hours to 1 hour. That's that. Next slide, please. Mechanical, similarly, same standard, so we can move on as the other restraints. Please continue. Okay. Again, this is pretty much the same. We seem to have. All right. Let's just stop right here. Because this is really the second part of this discussion, and we've got about a little less than a half hour. So the prevention of the use of restraints is what the department did during the SAMHSA grant and what they did in the years after the grant. And it's an affirmative obligation of all hospitals, not just state hospitals, to minimize the use of restraint and seclusion, prevention and minimal use of restraint and seclusion. It doesn't say elimination, which, I think once you start changing the language from the elimination of restraint and seclusion to the reduction, be better that you have the goal of elimination, because I think when you have the goal of elimination, it's a higher standard and you might have a better success rate. So this stuff, the bolded issues here talks about, they've got to have a plan. They've got to post the plan and policies and procedures that support the plan, training of staff, programming, development and integration of peer and family support. This is a good thing, but it also sometimes raises questions because not everybody wants their family contacted. So, and also sometimes peers, in my experience, do not want to be a part of the whole restraint process. I think it's good that peers provide information and insight into the trauma of restraint and to work towards the elimination of it. But I know that peers do not want to be involved in the actual restraint itself. Next slide, please. So, and then this is also, I think we have to go back yeah. So F, develop abuse of sensory interventions. This has been really helpful. Same with comfort spaces. There's an interesting concept about consenting to restraint. I've had clients who said that they've asked the doctor to put them in restraints, and the doctor agreed and put them in restraints. That is absolutely not allowable. You could say, well, that's client-directed care. The client ought to be able to do that. But it's such to use the language of one of the regulations, it's such an unreasonable thing to do. It's such a violent thing to do in and of itself. The use of restraints upon request is not allowable. However, some persons, there's weighted blankets that they use they're pretty heavy. They have I guess weights in them, but it's all sewn in, and people get comfort from that. It's kind of like a big hug. And so the use of sensory interventions, comfort rooms, music, sometimes like aquariums or aromatherapy, these have been proved to be very, very helpful. I think the other part of that, and the development of the individual crisis prevention plan, which we're going to talk in more detail, but also just understanding trauma. We all experience trauma to greater and lesser degrees. Trauma debilitates people, post-traumatic stress disorder. It is very hard to shake, and it often leads to psychiatric problems. It often leads to hospitalization. The trauma experience could cause a person to become agitated in a hospital situation. And the last thing you would want to do to that person is to re-traumatize them again. That it would be in any way it'd be a good idea for that person to be placed in restraints. It is antithetical of what should be doing. So understanding trauma. And then Jay, who talks about debriefing, we'll get more into that about. And then addressing patients' concern and qualities and data to improve monitoring. So when you ask me, shouldn't that be red flags? I'm not going to show you this, but when you have a document which says we had 60 plus mechanical restraints and 45 times we then added medication to that restraint, they're clearly not use of data to monitor, improve the quality. So that has to be drilled down on. Next slide, please. Staff training, really important. Similar stuff, impact of trauma, side effects, physical effect. And, there's no question about it. Staff get hurt also. Staff are traumatized by restraints. Staff are sometimes injured when they're trying to do enact a restraint. People are, people have to take off from work. People are really troubled by the whole experience. A lot of people didn't go into the helping profession of being a nurse or a direct care worker to engage in this kind of violence. There's no other word for it. Restraint is violence, and the violence causes trauma to everyone. Everyone. I mean, maybe it sounds silly, but I'm not meaning it to. Reading about restraints and what happens in hospitals is very disturbing to the attorney who's reading the medical record. It is really, really, it's something from the dark ages. And, a lot of people say, well, we don't want to lose that ability. Well, we had a reduction of by 1/3. The numbers that I'm seeing coming in from hospitals, particularly state hospitals, I'm sorry, state hospitals, I think the privates are doing a better job, at least what I've seen, is that the numbers are plateauing. They're not getting anywhere close to zero. The number of restraints that occur across the state is I would say it's around the level where it was pre-grant. Next slide, please. I think this just is going to continue with staff training. And here they say right off the top, applicable legal and clinical requirements for restraint and seclusion. Well, that takes us back to the slide, right? That takes us back to the imminent danger, the ability to affect the harm. I think people need a refresher in that training. How to safely do a restraint. I mean, there are methods. I have never been trained in it. I know that people, when we had the grant, People did volunteer to experience restraints. It was not a pleasant thing to experience. And techniques to release the person as early as possible. Now, a clinician might say, well, that's the reason we're giving medication. And you know what? I agree with that. You give somebody medication, that probably will reduce the amount of time the person will be in restraints. But you need to think of it differently. The clinician needs to think of what that medication is for. That medication is not a behavioral restraint. That medication is treatment, and it's treatment without consent. And you need to have some basis for justifying giving somebody treatment against their will, either an emergency standard or a court order. Next slide, please.
Can I just jump in?
Yeah, of course, please.
Some comments from the chat that I think are really valuable.
Great.
I think peers have a vital role to play in reducing the incidences of restraint. If there were a peer on call to observe the restraint process when it occurs, everyone would be more mindful of the law. I think that's a really good point.
I think it's a great point.
The staff have choices and certainly know what the job involves and choose to do it anyway. The patients have zero choice, which I think that's it's an important comment because it's highlighting the power dynamics between patients and between treatment staff. And then
Absolutely. Please, go on.
Monitoring and analysis for individual use and aggregate data is often where systems appear to fall down. So just wanted to share those comments. I think those are highlighting some serious issues. I really appreciate the comment about a peer on call. I think that's really important. The more you involve peers who have experience, I think the more likely there's going to be less restraint, and I think treatment overall would improve. So I appreciate that comment.
I cannot disagree. I think peer involvement is key. And I think the peer movement should be congratulated. I think that the whole, anything from warm lines to restraint and seclusion reduction, all of that stuff originated with peers. Peers who told their stories, what it was like for them to be in a hospital, persons who were victims of domestic violence who later found themselves in a hospital and now they're what they perceive to be a victim of institutional violence. And I have to agree with them. And all of these comments are great. Data, peer involvement, filing complaints, filing appeals, talking it up. Just anywhere you can, state mental health planning committee meetings, human rights advisory groups. This needs to get back on the dashboard of all hospitals in the Commonwealth. Next slide, please. Bingo, here's the other big slide. This is a little wordy, but I'm gonna try to break it down. One of the best things that came out of the SAMHSA grant was the creation of individualized crisis prevention plans. This is a theory which doesn't always work because it basically has two parts to it. The first part is that, and we could leave this up or click through, but basically the idea behind the plan is people know their triggers and people also know the things that help them de-escalate. And this also puts an affirmative responsibility on the facility to get that information up front. So the part in bold, an individual crisis prevention plan is an age and developmentally appropriate patient-specific plan that identifies triggers that may signal or lead to agitation or distress in the patient, and strategies to help the patient and staff intervene with de-escalation techniques to reduce such agitation and distress and avoid the use of restraint and seclusion. So we can go to the next slide. So it's a great idea, but a problem with the plan is that I'm not sure it's happening. When these ideas first came out, like let's say I'm a nurse on a unit and I'm responsible for a section of the unit or certain patients that are under my care. the individual crisis plan should be an index card that's laminated that a person can keep in their pocket, or even, I mean, not to violate the HIPAA rights of individuals, but the people on the unit all should have copies of the individual crisis plan at their fingertips, that they know this. They know this about Walter Nunes. They know that Walter Nunes, certain things will get him upset. Maybe a type of movie, I don't know. And there are certain things that help Walter Nunes calm down. And what I don't see it happening. To tell you the truth, one of my colleagues told me that comfort rooms are being used by staff. I'm not saying that staff aren't entitled to comfort, but the comfort rooms are there so that persons can, segregate themselves in a comfortable space, sit in an easy chair, maybe listen to music, maybe watch the fish in the aquarium, and they're not being available. I've seen hospitals where they lock the comfort room, which was astounding to me. So it's a great idea. And also, and this, I've always kind of struggled with this, the idea that not only the triggers and the strategies, but if a person, if restraint becomes necessary and it meets the test, does the client have preferences? The gender of the persons involved with, whether they would prefer medication over mechanical. Speaking only for myself and only using my imagination, I think I would much rather be knocked out than placed in mechanical restraints. It's not always able to happen depending on the severity of the situation. But the plan has to be updated, and it, like it says here in the bottom paragraph, all staff has to have access to the plan. Next slide, please. I'm trying to go fast because I want to leave room to talk. Now, here's the other part where the individual crisis plan, this is key. And I like what the first sentence here, recognizing that an episode of restraint or seclusion is a traumatic event affecting patient, staff, and the milieu. Debriefing is critical. And you can move on. So the debriefing activities, basically, what did we do wrong? Because if you view restraint as we failed, we, the staff at the facility, have failed. We didn't know the client's triggers. We didn't know the warning signs. We didn't have a laminated card that we could refer to. We got caught unawares, and it was a vehicle rolling down the side of a mountain without brakes. Nothing they could do to stop it at that time other than restraints. And I think that is often when a lot of this stuff gets done. But, if you really know the people you serve and you work with them with compassion and you understand something about their history, you have a much better chance. So the staff debriefing says, what happened? What did you do wrong? And this should be, I'm not saying to put the staff on the carpet, but they ought to be able to articulate what happened, what they tried to do, why it didn't work, and most importantly, what we can do better the next time. Now, there are things here, consideration of number 5, counseling for medical evaluation and treatment for the patient or staff involved. That's good, but that's also after the fact. Next slide, please. Patient debriefing. This is something that peers are involved in. And the patient debriefing form asks lots of the same questions. What brought this on? What happened? I mean, I've read reports. I mean, I think one of the worst restraints that because it was so avoidable. There was a patient on a unit, and he woke up at night, and he was hungry, and he wanted cereal. And he went to the charge nurse and he said, I'd like some cereal. And the answer he got was, we're too busy. I'm here at the desk. I don't have anybody to help me. Long story short, he kept going up. He got more and more upset. And this ended up in being an extremely violent restraint where the person's collarbone was broken. Now, that's an extreme example, but it's a factual story. So what I'm finding is that on the debriefing side, patients often don't want to discuss what happened. Sometimes people will write very choice comments on a debriefing form, or they'll just won't do it at all. And the reason why this is a problem, although I understand why patients don't want to talk about it, because they're angry. What do you mean you want to debrief me? You've restrained me. What I have to tell you about? I mean, but without this feedback loop, without having the individual crisis plan, and then more information. Again, it's the idea that the more we know, the more information that staff has, the more we know about you as an individual, the greater likelihood is that we will be able to prevent this from happening again. As a side note on this data that I'm looking at, we often hear about what they call the outliers. When hospitals have high restraint numbers, they blame the patient. For example, at one of the hospitals, 3 patients had 23 of the episodes that took place in a given month. So they're saying, well, this is a particularly difficult person. Well, I think that's a pretty crappy excuse, forgive my language. I think that if a person is getting restrained that often and for that amount of time, that you've got to double down on what's wrong in this situation. What can we be doing to not have this continue? It's really come to the place where they say, Walter Nunes he's destroying our numbers. We would have only had 15 restraints last month, but Walter Nunes had 30 of them all by himself. So that's why we have 45. Well, that's not a good attitude. And I'm not saying anybody has exactly said that to me, but that is a common response. That's why the data collects that. That's why the data shows those numbers. They can say, well, yeah, we had a high number of restraints, but it was just Walter Nunes because, he's a difficult patient. Well, difficult patients need extra attention, if you want to call them difficult patients, but maybe patients in need of care might be a better way to look at it. Next slide, please. And this just goes on to provide, this process. But this is where the feedback loop breaks down. If patients are not giving the feedback, what happened? For example, I went up to staff, I asked for cereal. They wouldn't give me cereal. I kept going back. They kept ignoring me. I mean, the number of restraints that people feel like they are being ignored is horrifying. Now, if that isn't something that should be easily done, and you don't need a laminated card to tell you not to ignore the people you're there to serve, I think many restraints can be prevented, particularly when it's the when can I go outside question, which also ties into the access to fresh air. Smoking. I know one of my good friends, I'll just call him John. John is a big fan of smoking, and he believes, and I understand where he's coming from because I used to be a smoker, that if a person could just have a cigarette, that would be a great way to calm them down. And I'm not a smoker. I don't support smoking, but I used to be a smoker, and I know that there is a quote unquote therapeutic aspect to having a cigarette, which has been denied. Going out for a walk, fresh air. Listening to music. Sometimes people can't use headphones in a facility because the cord is considered to be a risky thing. So getting the debriefing part, because the idea is you create this crisis plan, you update it, and the key part of updating it is what went wrong on this restraint and what should we have done to prevent it from happening. The fact that these numbers are going month to month, and we've got 54 one month, 39 the second month, 57 the third month, 61 the fourth month. It doesn't appear to be, these numbers are not going down. Next slide, please. I think this is another debriefing. I'll point out the patient should be notified of the complaint process. So the department here is saying, you get restrained, file a complaint. I think that's a very good idea. But you got to be prepared to appeal the complaint because usually you got to get up to a higher level to get the kind of result you're looking for. Next slide, please. And I'm trying to leave at least 5 minutes to talk. This is the question that somebody talked about, red flags. Senior administrative review. Next business day. I called an executive of a hospital that'll be nameless about a client of mine who was being restrained all the time. And I spoke to the executive director of the facility, and I mentioned the client by name, and I said, what's going on here? Person had no idea who the client was and had no idea that the client had been restrained incredibly frequently. So, a patient or staff member experienced emotional distress, restraint, and we didn't get into it, but restraints can be re-upped. I mean, the initial restraint may be for 2 hours, but it says here, a restraint or a seclusion exceeding 12 hours within a 48-hour period. This happens. Again, the episode appears to be part of a pattern warranting review. That's the example of using medication on an already restrained person. That's a pattern that warrants review. So with that, we're coming down to the wire. I want to stop yakking, as I do quite often, and I really want to open it up and ask as many questions as possible, and when I'll try to answer them, because I really want to hear what you have to say. Thank you.
Thanks, Walter. I just want to read a comment. I think a way to reduce restraints is by removing things that could turn into a power struggle. As an example, if I'm hungry, I want to be able to eat. Why can't hospitals have snacks easily available to people that they don't need permission to access? And I think that's a really good point.
A lot of them do. A lot of the privates do. I don't see it in the state hospitals, but I think that's a great idea. Go on, please.
We have a question. Is debriefing documented? Do you think that it's a lack of responsiveness or care for the trauma experienced by staff that leads to the apparently routine use of medication restraints? Perhaps it's based in fear.
I can't answer the motive. When I've questioned people on why you used medication on an already restrained person, you routinely get it to reduce, the answer is often to reduce the amount of time the person was in mechanical restraints or to ease their suffering. And that's why I wasn't being funny when I called it a compassionate restraint. It's illegal, but the motive is to calm the person. It's not lawful, but that's usually what it's done. I hope that answered the question.
Can you request information on who is doing the restraints? It may be a flag that the same staffer is not trained or is ignoring the procedure.
Yes. Every time there was a restraint and seclusion form, which I could even, if you like, we could make available a blank one so you could see it. We could make the matter of fact, I'm pretty sure they're on the DMH website. Also the debriefing forms. Yes, it does identify who is involved, the antecedent behaviors, the steps that were taken to mitigate or to prevent the restraint or seclusion. So yes, it does identify it. And yes, part of the senior administrative review, the debriefing process, the staff training. If you as an individual, again, I'll use my name, if Walter Nunes is always there when people are getting restrained, you got to look closely at Walter Nunes and say, what is going on here? Why does this person do more restraints? Another common fact is that shift change is a big time for restraints, particularly the 7 to 3 and 3 to 11 in that 2 to 4 hour when staff are changing and they're talking to the person who did the day shift and they want to know about problems. A lot of restraints happen during change of shift, and that should be a pattern that warrants review. Please go on.
We just had a question if we might address the shock collars ban that was recently overturned at JRC in Canton. And I know a little bit about this case. My understanding is that the shock collars were not being considered or used as a restraint, but rather they were being used as treatment. And it was actually the Food and Drug Administration that banned the collars, and the U.S. Court of Appeals overturned that decision based on the statute that the FDA is enabled under.
In course, just out of sympathy to time, the use of aversives is unfortunately allowable in Massachusetts. Shock collar is not generally the term that I hear. It's graduated accelerated de-escalation, right. GED, and they put these devices like almost what you see when they're doing testing for heart attack. They put those little stickies on people. Well, they put stickies on elbows and some very sensitive parts of the body. I've never heard of a shock collar as something that you put on a dog, for example. Matter of fact, it's illegal to put one on a dog, an anti-barking, but it's not illegal to use electricity It is not restraint. Well, it is negative behavior. It's the idea that if if you want to go to the party, make your bed. That's what my parents would say to me. But these are not the parents. This is the state, and it's not making the bed or going to the party. It is the infliction of pain on a human being to correct their behavior. Correct. Bad choice of words. To control their behavior. I had clients at JRC. They were grown men of very low developmental. Their actual age and their intellectual age was dramatically different. They were basically toddlers, and they used these devices for people on years for behaviors which I think would certainly not result in the shocking of a baby or a toddler, such as incontinence. If there's anything more barbaric than restraint and seclusion, it's the use of GED. There's no question about it. That's all I can say. But it falls outside. They don't do this at DMH facilities. It is not part of the restraints. DDS, as I understand it, they're not in favor of this. But it is allowable, and we need to keep. And DLC is committed to keep fighting this fight until it is no longer allowable. Most of the
Walter,
states in the United States. We are all done. I understand.
I think we got to wrap it up.
Okay. Again, I know I have a tendency to talk to, but
points are very well received, and I totally agree. But we got to wrap it up. I want to thank everyone for their comments. This has been a really great training, and our next one will be on August 24th, concerning the process for filing a complaint with the Department of Mental Health. So please join us for that training. And
thank you, Ginger. And again, if you hear of a particularly bad situation or bad hospital, let DLC aware of it to talk about restraints and the use of restraint and seclusion. We're very interested and committed to eliminating the use of restraint and seclusion, not just reducing it. Have a good day.